Deadline on judiciary's sake, for judiciary's sake, on
You're live.
Thursday morning, I'm gonna go in to their committee and just report on whatever whatever decision we've come to, or no decision, if that's the case.
We end up regardless having a straw poll, straw.
Yeah, I mean, I made ask for a straw vote today just to see where people are tentatively. But I'm also feeling like, and I'll leave it up to the committee, I guess. But I don't want you to all feel like we have to make a final decision today. Some of you may feel that you're ready to, and that's fine. So we'll see where we are. I know, John, you said you have to leave it at 2:30. Yeah. So I just want to be sure that if there's any questions you have or anything you want to share, that you have a chance to do that. Anyway, so I'll turn it over to you, Mike.
Okay, this is Mike O'Grady with Budget Council. I guess the first thing I'll address is what authority do municipalities have to regulate farming? And the short answer is not much. So in 24 VSA 4413, this is a statute that lays out the limitations on municipal authority to regulate through planning and zoning. And there's a provision in 4413 that says a bylaw shall not regulate required agricultural practices, including the construction of farm structures, as those practices are defined by the Secretary of Agriculture, Food and Markets. And then it goes on to define what a farm structure is: a building, enclosure, or fence for housing livestock, raising horticultural or agronomic plants, or carrying out other practices associated with accepted agricultural or farming practices. It does exclude a dwelling for human habitation. So farm housing is not a farm structure. That's an issue that you probably have heard of before.
Farm worker housing?
Right. So,
Representative Nelson.
Yeah, so how would that apply to buildings? I've lost that term. Accessory farm buildings.
well, that's another aspect of the law, because that is not farming. It's just something that you have deemed to be related to farming, and therefore to enjoy some of the regulatory benefits of farming it because it meets those criteria. That's not farming. It's just a business related to farming.
So do the towns have authority over those? Like if you had a little building you're selling, strawberries out of? Farm stand.
Well, that's farming.
That's farm.
That's
Okay.
farming. I did not bring the accessory on farm business statute with me, sorry.
He will, I think, well, have an opportunity to delve into that next week, actually.
Okay.
Thank you.
John?
Mike, as a good example, can you just give us a quick narrative on that whole MS4 municipality versus farming thing? What happened with that? Because
Sure, that wasn't an MS4, well, it was an MS4 community, but it was more about a stormwater utility assessing a farm stormwater impact fees underneath a municipal ordinance or bylaw. I argued that they didn't have the authority to do that, and they argued, the municipalities, that because the limitation says a bylaw shall not regulate required agricultural practices, that they weren't actually, the bylaw at issue was not regulating the farming practice, but the stormwater coming off of the parcel. And I argued that that's not the way that provision has been interpreted. I mean, to mean, it's been interpreted to mean the municipality doesn't have the ability to regulate farming that is subject to the RA fees. And that's ultimately where you settled, and that they cannot assess the stormwater utility cannot assess the farm stormwater impact fees or assessment fees. Which some of the municipalities weren't happy about.
Is that case law?
There's the statute and there's case law about the effect of or the reach that municipalities have and the regulations. The decision you made about the application of stormwater utility fees to farms, you made legislatively.
We did that, was that last year or 2 years ago?
2 years ago, 2 years
In
ago.
our miscellaneous ag bill, yeah.
Yeah. One of the questions that someone asked last week is, well, what are agricultural districts? Because municipalities can zone for agricultural districts, and in most places in the country, an agricultural district is where a municipality is basically incenting or encouraging or requiring farming to be engaged in, like Oregon, which is very heavily planning and zoning state. This is where you will farm, and you farm in these ag districts. That is not what an ag district is in Vermont. An ag district in Vermont is almost the exact opposite. It's to protect the ability of farming to farm in that area, but it doesn't require them. If I can find a specific section, it's got some clear lines.
Zoned agricultural?
Yep. So an agricultural, rural, residential, forest, and recreational district where it is deemed necessary to safeguard certain areas from urban or suburban development and to encourage that development in other areas of municipality or region, the following districts may be created: agricultural or rural districts, permitting all types of agricultural uses and prohibiting all other land development except low-density residential development. So it's basically to keep development out of the district, not to encourage ag to be in that district. I mean, it has the effect of encouraging ag because you're keeping development out of it, but it's not like what other states do in driving farming to certain areas. This is basically driving development away from certain areas.
Okay, so Representative O'Brien.
What happens with, I know this is more Act 250 land, but when a town plan, say, wants certain areas to be agricultural or not, similar?
It's just, you can encourage farming to be in certain areas through your town plan and through ordinances. It's not required to be. And in fact, because farming is exempt from municipal regulation, it can occur effectively anywhere and qualify for that exemption. I think you are seeing a very highly publicized case of that in Essex, where there was an individual who started farming ducks on a quarter acre of land and was deemed to be farming and therefore exempt from municipal regulation. The municipality is challenging that, but I mean, that is those types of scenarios arise. Now, when I first started here, you had 2 chickens. You could argue you were farming. And that led to these issues. The one that I remember the best was in Barry City, and a person had, 20 chickens but 4 roosters. And the roosters were not well liked in the neighborhood. And the municipality tried to regulate them away, and the person kept on saying, no, I'm farming. And the agency basically wanted to say, no, you're not farming. you're just got chickens in your backyard. And so that's where they came up with the floor for the RAPs, where you have to have a certain amount of income or a certain number of animals in order to be considered farming. So just because you have a chicken or a donkey, you're not considered farming.
So what we're talking about here is what we describe as farming or agricultural activity. So it's nothing in this bill that we're going to be looking at again in a few minutes speaks to the person who has 4 roosters in it today in his backyard, and a neighbor's ability to say that's a nuisance. Is that correct?
That's correct. I mean, one of the things that your draft does, or judiciary's draft does, is conditions their ability to assert the nuisance protection on being in compliance with the RAPs. So if you're not subject to the RAPs, you don't qualify for this protection.
4 roosters that's a lot of roosters even for somebody's backyard, but in terms of, just because we think in terms of cows often, can you just remind us, how many cows do you need to be subject to the RAPs?
Oh, that's the wrong thing. $2,000 threshold for income. For the price of beef these days, 1.
It's 5 cows according to Steve. I'm not bringing the RAPs with me.
Okay.
All right.
5 cows is one way of qualifying, and $2,000 is another way of qualifying.
And 4 horses, Steve? 4 horses. And 30 chickens.
So a small number of various animals, you're not farming. This nuisance protection doesn't currently apply to you, would not apply to you.
Right.
Chuck,
Mike, has anybody tried, say you're Global Foundries and you have 10 horses, can they say they're a farm?
I mean, people have tried that,
Would assume, yeah.
and to relative degrees of success. Usually what happens is they abandon the activity that's farming in pretty short order and lose that exemption. But it's happened. It's 50 turkeys, it's 50 geese, it's 100 laying hens. It's 250 broilers. So it's a pretty substantial amount of number of poultry.
right? Any other questions about the intersection of municipal laws and farming? So generally, farming is not something that municipalities can limit or restrict.
Right, they try, and most notably around farm structures and fencing. Just this past year or two, I've had multiple members of the General Assembly say, my town is trying to enact fencing requirements for farming. And I'm like, well, they can't do that. They still try to do it. They try to get the municipality, the farmer to have to challenge it. So it happens. And as Steve said last week, the agency encourages farm structures or farmers to comply with setbacks for farm structures. But that's not actually required. It's something that the agency controls. They can say when the farm structure can not comply with the setbacks. So that's something the agency works with municipalities on to try to comply with that, but it's not actually, you don't actually have to meet the municipal setbacks if you get an agency approval.
Can municipalities bring complaints to the agency that somebody's not following the rules?
Well, usually what they do is they ask if the activity is farming. And that was more important before the accessory on-farm business provisions. But it still has the opportunity to recur, I think. The biggest issue while I've been here on the question on that is composting. When there were farms that were taking food residuals for composting and then running a composting business on the farm. Or even just importing manure onto a farm and other inputs for composting. You had the issue with Vermont Compost up in East Montpelier. You had the issue with the Audax. Was it the Audax in St. Albans? Food Act. And so there were a couple of issues with that, and you enacted some provisions to allow for certain composting facilities on certain size farms to be considered farming, exempt from Act 250.
Or solid waste inputs, right? Because that's a,
Well, that was part of that compromise, that if you were only using certain inputs, you weren't using, plastic or other types of waste, that you could qualify for the compost exemption. That was part of the compost wars. The compost wars have been ongoing.
Right. So based on the discussions we had last week, I asked Mike to put together this draft and asked him to do a series of things in it. So I'm going to list what those things are, and then we'll have Mike show us what he's come up with. But the first one was to remove the existing restrictions. And this is all, I should say, this is all compared to current statute. So when I say remove, I'm talking about what's in current statute, remove or add or change. So first, to remove the restrictions on changing the method or type of farming. So that currently, if you change the kind of farming you're doing, change what you grow, as a farmer, you're no longer eligible for the nuisance protection that we have in law. So this draft says you can now change the kind of farming you do, doesn't put any further limitation or restriction or description on that. So any kind of a change that you might imagine.
if you're farming already, you're talking.
We'll get to that one in a second. But you can, if you are farming right now, yep, you can switch to a different kind of farming and you don't lose the protection that statute gives you. So I asked him to do that. And then I asked him to remove the existing consideration about who was there first, the neighbor or the farmer. So right now, if you're a farmer who, or if you're somebody who starts farming, and a neighbor is already there, being a neighbor, has a house, this protection is not available to you. So based on the conversation we had last week and previously, I think we felt that new farmers who haven't farmed, new farmer conducting new ag activity on a parcel of land ought to be eligible just as much as somebody who has been farming there forever. So that's in here. And then I asked him to shift, to make whatever changes were necessary to current law to remove having the burden of proof on the farmer. So basically, where we're currently saying the farmer has to show something to qualify, that now is removed and put onto the plaintiff, the neighbor. Right now, in existing law, there was just a couple things I think that had to be, that the farmer had to prove, but one of them was that they were in compliance with the RAPs, and then that might in fact be, could be a difficult lift. So this, in any case, shifts that responsibility onto the plaintiff. So those three things I asked Mike to do. And then I also said, I think we are okay with the mediation requirement that is in the draft that we've looked at. It's not something that's in current law, so include that. So you'll see that in here. And then there are a couple of other things that I am going to assert. I don't know whether they are big things or small things, but we can discuss them. One is there's a line or two about liberal construction at the end. Mike, I think you talked to us a little bit about this one of the times you were in and what the implication might be of that. That's in here. And then there's existing language that talks about good agricultural practices. It's a little vague. So now we have this new definition of generally accepted ag practices, which is intended to be more specific, I think, and make it a little more of a challenge for, well, maybe it's not intended to be a little more of a challenge, but to be a little more specific. And then the only requirement that's in here for the farmer is to show that they are in good standing with the state. I think that's the only requirement. That requires getting a certificate from the agency saying, you aren't doing anything wrong at the moment. So that's, I think, what I asked you to do, Mike. I will just say, since that's all I asked Mike to change from existing law, there is nothing here about trespass, which I think the committee was supportive of. There's nothing, and nothing at all about water, excess water. So it doesn't seek to address that issue at all. John.
So are we getting rid of rebuttable presumption and replacing it with another phrase that we can?
Yeah, so the phrase rebuttable presumption is gone. There is, and I'll let Mike speak to that because I think it may be a little bit of a, that's one way of describing something and here's another way of describing something, because there is still a way for the neighbor to say, there is a nuisance here. Anyway, Mike, you want to take it from there?
I'm just going to walk through the entire bill, if that's okay.
Yeah.
So section 1 is the addition of the chapter to Title 12. It's existing. It's in court procedure, and it's in court procedure because it directs courts how to address nuisance claims against ag activities. To further highlight the purpose, you can go to the bottom of page 1, going on to page 2. In order for the ag industry to survive, farms will likely change, adopt new technologies, and diversify. And the General Assembly finds that they are subject to lawsuits based on nuisance. And these suits could encourage and force the premature removal of the farmlands and other farm resources from ag use. Therefore, it's the purpose of this chapter to protect reasonable agricultural activities conducted on the farm from nuisance lawsuits. You get the definition of agricultural activity, which is actually very important, especially when looking at the reference to agricultural activities as defined in CSA 4802. That was added in 2022. And it includes the fact that the farm can expand farming practices or ag activities on a farm, or the change or conversion of farming practices or agricultural activities to other farming practices or agricultural activities. So change in type, change in scope, change in practice, that's all defined under agricultural activities in 6 VSA 4802. It includes operation of farm machinery and equipment. It includes drainage systems. It includes movement of farm vehicles and equipment. So it includes modern agriculture and the ability to confer and change practices in modern agriculture.
Just gonna pause here, interrupt you, Mike. I got several emails over the weekend from people saying this, the version that we're looking at doesn't allow new farms to come in. And I tracked down the source of those comments and reached out to the person who admitted being responsible for spreading that information and somewhat sheepishly said, I'm sorry, I was looking at current law, not even what you're working with right now. So just to drive home how a lot of the comments that we get from people aren't always necessarily as well informed as we would like. And if for understandable reasons, it can be hard to find what we're working on right now. But what we've got right here, just to again say, it's not excluding new farms. It's not excluding, it just covers everybody.
Right. And so the farm, in order to be awarded nuisance protection, liability protection from nuisance suits, will have to show that their activities are consistent with generally accepted agricultural practices. And there is a definition of what that means, whereas there isn't a definition of what that means in current. So the farm will need to show compliance with the RAPs. They will need to show compliance with the CAFO permit, if applicable. They will need to show compliance with the rule for control of pesticides. And then at one point, you were talking about taking out sub D, practices conducted in a manner consistent with proper and accepted customs and standards followed by similar operators of ag activities in the state. I think this is very important to include because the RAPs is really a water quality requirement. CAFO permitting is a water quality requirement. The Agency of Ag's pesticides requirements are just pesticide. So there are no standards for noise, dust, traffic. Those are some of the more common nuisance issues. And because there are no standards for them, you have to provide this kind of narrative standard that will allow a court on a case-by-case basis, based on the facts, to determine whether or not the farming practice is consistent with proper and accepted customs and standards followed by similar operators. I think if you don't include this, it actually makes it very much easier for a farm to qualify for nuisance protection and very much harder for a person that's affected to show that they are affected. So that's up to you if you want to include that.
So I think, I think that was a question, it was my question that came up, and I don't think anybody else was suggesting removing it. So I'm glad that we've got it in there. John.
What I really like is the in the state part, because I think, the agri practices in other states can be wildly different than what we do here. And so if that's sort of the baseline we look at, and I mean, the more we can make this a Vermont specific statute, the more I like it.
I would, from a drafting perspective, it would be great to be able to say, and the noise and dust standards or the traffic standards, but there's none of that. There's nothing you can point to. So it has to be something that's reviewed based on the practices in the area, in the state.
So it's one part I have about this sentence is say, everybody planted corn by, first tilling and seeding and spraying. Now, I see a lot of people doing cover crops, glyphosate, and direct seed planting. could it be argued like, well, like if somebody's doing, if you're the first guy ever to do that, right? Are you doing something that's inconsistent with
Well-
proper and accepted customs?
Well, first you are allowed to change your practices, right? We already talked about that. So if you are the first, you're probably going to have to show why you're doing and the basis for that, and whether or not it would be accepted, proper and accepted customs and practice by similar operators. It might be harder if you're the first person to do that, but you'll still have the opportunity to make that argument.
Remember, Brian?
And Mike, the other thing on the new farmer exception, is there sort of a grace period at the agency where, you know, if I'm a new farmer and I'm ramping up and I have, you know, only half the dairy cows I need this year to be eligible for the wraps? Is there sort of a, you know, a probational period where you can say, I'm in farming, you know, financially and animal wise, we're following the reps, but we may not make 2,000 a year yet, or we don't have, you know, those numbers of chickens or beef calves. Would they be covered?
First, there is no new farmer exception. It's just if you are farming that and you are engaged in an agricultural activity, which includes all of these various ways to qualify, including farming under Act 250, farming under the RAPS, which is the same thing as Act 250 for the ag activities in 606. You can assert that you are an ag activity. You're going to have to prove that you meet all the generally accepted agricultural practices. If you're an animal farm and you have, what was the threshold for chickens? It was 100 laying hens, right? But you only have 50. Well, you're not subject to the RAPs, so you can't argue compliance with the RAPs.
Okay.
So you're not going to qualify. This is about protecting farming and not, you know, homesteaders, which might not be what you want, but that's really what it's about, protecting farming.
I was just thinking, I mean, I can see a certain amount of farmers, if Greg, you know, puts up a new sugar bush with pipeline, he hasn't made $1 off it yet. And, you know, if he didn't have his other part of the farm, you know, if he was just a new sugar maker.
Well, Steve, can I have the RAPs?
Business farm.
Yeah. So for maple, you probably don't need to show the 2,000.
You could still qualify without that money threshold.
Potentially, yes. Yeah, right. So the agricultural practices on farms meeting the minimum threshold include the collection of maple sap principally produced from trees on the farm and or production of maple syrup from sap principally produced on the farm. So you can do that by $2,000. You can do that by you're preparing, tilling, fertilizing, planting, protecting, irrigating, and harvesting crops on a farm that is no less than 4 contiguous acres in size. I mean, so you're 4 acres or more in size and you're collecting maple sap, or you're going to qualify.
So you could qualify for farming and still lose money, essentially, as we look at a lot of farms lose money.
Most of us do. Like longer.
And it does say gross income, so 2,000 or more, so you would have to qualify under another criteria if you're losing profit that way. Should I go on?
Yes.
So as the chair noted earlier, one of the things that a farmer will have to show in order to assert nuisance protection is that they are in good standing with the state. And so there's that definition. This definition is a little bit different from how good standing with the state is normally defined. So good standing with the state is normally defined to not have an active unresolved enforcement violation that has reached final order stemming from the agricultural activity at issue with the Secretary of Natural Resources or the Secretary of Agriculture, Food and Markets. So I was asked to take the final order provision out. So this may make it harder for some farms to assert nuisance protection. So let's talk about that a little bit. So why is good standing in here to begin with? Because the Judiciary Committee didn't want a bad actor to qualify for nuisance protection based on the activity that is subject to enforcement. And so they were looking for a threshold hurdle to show that the farmer was complying with the law to the best of their ability. And the good standing in the state is used in a couple of different places in ag law, most notably in order to qualify for financing, for financial assistance. Because generally you don't give money to people who are violating the law. But what balances that out is that when you created the Agency of Agriculture's Enforcement Authority for water quality and then later for their general enforcement authority, you told them to work with farmers. You told them to notify the farmer what the issue was, to give the farmer opportunity to review the potential violation, to give the farmer time to come into compliance. So they're subject to enforcement at that time period where you directed the agency to work with them, but they wouldn't be in good standing. So you're gonna put some farmers out of the nuisance protection provision if you don't contingent it about being gone to a final order.
Questions about that?
Yeah, I been involved in some enforcement violations. It happens. Not intentionally, but it happens. And sometimes it takes a month to resolve them. You need to have a break in the weather to be able to go in, and you may have to work with the engineer with the Agency of Agriculture to approve the plan to fix the problem. And it may take 2 months. And so I have a problem if I lose my protection because we're working through the issue. Now, if you get a final order and you're thumbing your nose at the agency and A&R and everybody else, fair enough. But if you're working through the equation, and sometimes you have to work through the equation to make everyone happy. That's my take on the whole thing. Right now, we're good.
Representative Pine.
So in the Worsted case, when the state or the plaintiff won that case against that farm, at that moment, are they not in good standing?
I don't think they would have been able to show good standing because they had active enforcement without had gone to a final order with A&R.
Concluded they would not have been in good standing. Does it matter that we've got this? We haven't got to it yet, but we have the mediation requirement at the end. I don't know how much time that typically would take or add to the process, but to Richard's point that it could take a couple of months to resolve. would the fact that you've got mediation built in sort of offset that somewhat?
Offset the enforcement?
No, just the time. So there's a timing concern that for a period of time before you got to the final action, the farmer would not be able to assert good standing because they were still in the middle of dealing with the issue. But the way that we currently worded this, we also have now the mediation at the end that you have to go through anyway. But would you not even get to the mediation because you couldn't cross this hurdle if you couldn't show good standing?
Right now, you wouldn't, if you were in an active enforcement, you wouldn't qualify. So you wouldn't have to go to mediation if you're not going to qualify for the nuisance
Yeah,
protection.
thank you for
If
clarifying.
it's subject to a final order and you don't have a final order, the mediation is really is a encouragement to address your issue without litigation. And to make you demonstrate that you attempted it. Mediation is going to last as long as the parties want it to.
So just, I guess I want to step back here and say that right now under existing law, there is no good standing requirement
For this protection.
for the protection in this section of statute. So I'm going to flag that because I had said, here are the things that are changing from existing law. This is a change from existing.
This is a change, yes.
So whether we use this language or modify it, go back to the language that came out of judiciary, it's still going to be a change.
Yes.
All right, so and if other people don't have any questions, we can move on, but I do want to flag this to come back to. And I'd like to, know what other people in the committee think about it before we sign off on anything.
What page is that on?
It's on the top.
Page 3,
Page 3.
18 is really where it would be.
118.
Should I move on? So then you get to the actual protection that's afforded from nuisance lawsuits, and you'll see it begins with striking the current standard. It strikes the rebuttable presumption. It strikes that you have to be in conformity with federal, state, and local laws. It strikes that it has to be consistent with good agricultural practices, but there's no standard for what good agricultural practices is. Strikes that it has to be established prior to surrounding non-ag activities, and it strikes the fact that it cannot significantly change since the commencement of prior surrounding non-ag activity. And then it also strikes the allowance for the presumption to be overcome or rebutted by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with use and enjoyment of neighboring property. But that language, those two standards are moving. It's no longer about rebutting a presumption, but you are now providing later on in the bill that the liability protection does not apply when one of those two standards can be proved. But the liability protection is here. It replaces the rebuttable presumption. It says no agricultural activity as defined in the bill, which includes change or conversion or modern farming, shall be or become a nuisance when the activity is conducted in accordance with generally accepted ag practices. So your RAPs, your CAFO where applicable, your pesticides where applicable, and then the customs and practices of similar operations in the state. And then in order to assert nuisance protection, a person conducting an ag activity shall demonstrate that they are in good standing with the state, and they may demonstrate that by providing letters of good standing from the Agency of Ag or the Agency of Natural Resources, or both, as relevant to the claim. And then a plaintiff alleging that an ag activity is a nuisance shall have the burden of proving by preponderance of an evidence that the ag activity at issue is not entitled to the nuisance protection because the ag activity is not conducted in accordance with generally accepted agricultural practice. So putting the burden on the plaintiff to show that the farmer is not entitled to nuisance protection. And then if they are able to show the ag activity is not entitled to nuisance protection, that the required elements of their nuisance claim, that the agricultural activity that's not entitled to nuisance protection constitutes a nuisance because it materially adversely affects the use and enjoyment of the neighbor's land. But then you get the nuisance protection for an ag activity shall not apply whenever a nuisance violation results from the negligent operation of an ag activity. The ag activity has a substantial adverse effect on health, safety, or welfare, or the ag activity has a noxious and significant interference with the use and enjoyment of the neighboring property. And then last, the chapter does not restrict or impede the authority of the state to protect the public health, safety, environment, or welfare.
Representative Nelson.
All right. Go back up to number 2. The agricultural activity has substantial effect on adverse effect of health, safety, or welfare. Who makes that determination?
That's going to be the judge's determination. It's going to be based on the facts at issue in the controversy, just as it is right now, because remember, this is one way that you can rebut the presumption under current law that it has a substantial adverse effect on health, safety, or welfare.
Okay. And on number 3, noxious and interferes with the use and enjoyment of neighboring property. We heard from one testimony on an organic farm about spreading chicken manure. And the neighbors harass them when they apply chicken manure. Having worked with chicken manure, not real fun for a few days. After that, it's fine again, but would that remove them from protection from nuisance? Because they're an organic farm and a great way to get nutrients on an organic farm is from chicken manure.
So again, this isn't going to prevent litigation. It provides the farmer with some protection if there is litigation. And one of the things that the farmer is going to argue in a situation that you just described is that what they are doing is a practice conducted in a manner consistent with proper and accepted customs and standards followed by similar operators of agricultural activities in the state. And one of the things that they're going to have to argue is that the fact that there is smell and odor or some adverse effect on the neighbor isn't sufficient to show that it has a substantial adverse effect on health, safety, or welfare, that it's a common practice in an agricultural community. And that's what they're going to argue.
Thank you for the explanation.
Representative O'Brien.
Do we define noxious?
No, you do not. You could if you wanted to. I don't know where I would start. I would probably go to the Worcester case where Judge Teachout did have a discussion of that. There are some things that you're probably just going to have to lead to the court. But if you want to define it, you can define it.
Both the 2 and 3, so 2 is there and then 3 is in the next page. That's existing language. And like you pointed out that in the existing statute, that language is part of here's how you rebut the presumption. So we've gotten rid of the construct of a rebuttable presumption. Instead, we've said you're protected from nuisance. Then here, a little further down, we're saying that you're not protected from nuisance if either of these are applicable. Is this different way of constructing the statute
It is.
an important way?
You know, there might be some advocates who say you're changing the standard of nuisance for farming by saying that the plaintiff has to show that the farmer doesn't qualify for nuisance protection unless these things happen. And so there might be an argument on that. It's very similar to the salt bill. I don't know how closely you've all been following the salt bill, but there was the argument that changed the standard for negligence. And how that bill sugared off is that instead of it being liability protection, it's an affirmative defense to negligence. So I wouldn't be surprised if some of the advocates ask judiciary or ask you to make this an affirmative defense instead of liability protection. Because they're going to argue that this makes it harder for a plaintiff, a person who was harmed, a victim, to access the courts and claim a remedy, which is it does. It's designed to do that. Instead, you should place the burden on the farmer to show that they qualify for the defense and allow the plaintiff who was harmed, the victim, to bring a claim under current standards of law. That is a policy decision. Part of the discussion pretty much in every committee has been to shift the burden from the farmer to the plaintiff. So I don't know how to shift the burden to the plaintiff and also provide that it's an affirmative defense. I don't know how to do that.
But this is another way in which it does shift the burden to.
You're very specific about that the burden's on the plaintiff to show that the farmer doesn't qualify for nuisance protection, and then the nuisance has occurred and is eligible for compensation.
Let's keep going here.
So getting to the next section, 5754, this section was a little bit longer than previous drafts. The first subsection there, this chapter is remedial in nature and shall be liberally. This is really about a message to courts to look at the purpose of this chapter, look at the facts involved in disputes, and to liberally construe those facts to effectuate the purpose of supporting farming, allowing farming to change, evolve, and to protect them from nuisance suits. That's what the liberal construction provision is. Severability is you honestly don't even need that subsection B, but it's current law. Severability is a concept that if a court found any part of your statute to be unconstitutional, the parts that were not found unconstitutional survive. They can be severed from the unconstitutional. They can be severed from the bad and continue on. There's actually a default severability clause in Title I. So you don't necessarily need this, but it's bootstrapping. It's whenever there's going to be a statute that has some constitutional implications, you'll see something like this. And then you get to the required mediation prior to suit. This is new. This is not in current law. There's not a lot of provisions where you have to go to mediation prior to suit. I think bankruptcy might be the only one that I can think of, and it's federal. So a person shall not bring a court action based on a claim of nuisance arising from an ag activity unless the person and the operator of the ag activity at least once attempt to resolve through mediation the issue or dispute that the person has concerning operation of the ag activity. The mediation shall be conducted according to the provisions of the Uniform Mediation Act. I said that this is not common, except that I drafted one of these for the Sports Shooting Range Protection Act. So that's also nuisance protection, and that also has a required mediation prior to suit. And then the parties to mediation may agree about the use of a mediator to assist in the resolution of the agreed upon issue or dispute. The parties shall share the cost of mediator equally or according to an agreement between the parties. Parties are unable to resolve the relevant issue or dispute, the parties may agree to submit the issue or dispute to binding arbitration. Person bringing a court action based on a claim of nuisance arising from an ag activity shall provide the court with a sworn statement of an attempt to resolve the issue or dispute through mediation. So again, how long mediation lasts is really about the parties. They find a mediator, they agree to share costs, they agree to meet. If they meet that first meeting and they can't resolve it, then that's it. They provide a sworn statement and they can access the courts.
We heard earlier that the USDA offers a free mediation service. So that's something to be aware of. John, I know you have to head out to free, yeah. Did you have any, before you leave, was there anything you wanted to ask or any thoughts on that? Do you have to leave too, Mike?
No.
One thing, and I think you already suggested to Mike and it got changed, was if this 124 passes and we have to change to, from LFO permitting to CAFO permitting, nothing would change in this, right?
No, because we added both. Because the first criteria is you comply with the RAPs or the requirements of 6 VSA 215, which is where the LFO permit is, or the MFO permit. And then the second is a concentrated animal feeding operation permit, if applicable or where applicable. So that's only if you're required to get one. So you wouldn't need to change anything.
In the case of, really bad farmer, say, uses a pesticide that's, shouldn't even be using, and there could be criminal action brought against them, then, civil can follow, right, too, with these sort of suits?
If they are using an unauthorized pesticide or an authorized pesticide, not according to the label or not according to the agency's rules, they can be enforced against if they create, and they would not qualify for this nuisance protection. And they would be subject to civil litigation for any damages that they caused. And there are, it's not farming, but there have been people that have used pesticides against the authorized use provisions or against the rules. And they've been subject to liability. And most commercial applicators, they have to carry, is it $1 million in insurance? They have to carry an insurance policy. I think it's $1 million.
John, did you have any thoughts on that one section where the certificate good standing was contingent on the?
I think what Richard was speaking to, as far as if mediation is in the works,
I don't think mediation is in the works. I do that.
Not mediation, not the mediation up here, but remediation, I should say.
Yeah.
Remediation is in the works between the farmer who's in violation and the Agency of Ag or ANR. There should be a grace period then until it's resolved.
Yeah.
Not, that wouldn't throw you outside the good standing.
Okay, good. Why don't we take 5 minutes just to stretch, and then we'll come back and continue our discussion.
I thought it was good. It was a good meeting.